So here we are, FTC bans non-competes. For some of you who are familiar with this, some of you may not be, but a non-compete is a pretty common practice that we've seen in the healthcare industry and really any industry. So I'm going to break down the actual ban itself, some of the exemptions, what that means for you as an employer, but also as an employee that may be subject to this. And at the end, we'll talk about compliance and maybe some strategies on how to deal with this. So for those of you who don't know, my name is Trevor Anderson. I'm the managing partner and founder of the Anderson firm. I have almost a decade of experience in healthcare law. Prior to that, I actually worked at Ernst & Young as a consultant for them. And now my focus is with healthcare clients and really private equity funds in the healthcare space, servicing a wide range of needs from transactions to regulatory compliance. So that's a little bit about me, but that's not why you're here. So let's just jump right in. So non-competes, what does that mean? Well, I think most people have a decent idea of it. It's a restrictive covenant that shows up in employment contracts. And the FTC has a very specific way that they've defined this that you can see here that was included in their rule. And what they've decided is they've taken on a very expansive role of non-competes. So, I won't read through the whole thing, but essentially anything that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from getting employment after their current employment term ends, or operating a business in the U.S. after the conclusion of that employment term. Really, the idea here was to prevent someone that you hire, so a worker or employee, from leaving and either joining a competitor or becoming a competitor themselves. I want to look at some of the words here because I think it's worth pointing out just how broad this interpretation could be. Functions to prevent. Okay, that's a very broad catch-all that likely will be subject to multiple challenges. In fact, it already has been. But what that means is an employment agreement may have a handful of different restrictive covenants in it. Could be confidentiality agreements, non-disclosure agreements, non-solicitation agreements or provisions, non-disparagement provisions, and then non-competes. So in a very literal sense, one might think, well, as long as I don't have a non-compete in my agreement, then I'm fine. But the reality is the FTC is going to look at the contract in its totality and see if the restrictive covenants function, right, act as though they are a non-compete, preventing the employee from working or starting or operating a business. So that could take the form of something like an overly expansive confidentiality agreement. In the context of healthcare, what that could look like is, let's say one of your physicians goes for a certification, right? A specific certification in their field that the employer pays for. Confidentiality agreement could restrict the knowledge and know-how learned through that certificate program from being used at a future employer, right? That is not technically a non-compete, but that is such a burdensome and restrictive confidentiality agreement that the FTC, under this language, would say that that is in violation of the rule. All right, it's non-competes. Now let's get into the actual prohibition itself. So the important thing to note here is the rule sets up two different classes of employees or workers. They have the non-senior executives and the senior executives. We'll go into what exactly that distinction makes, but for non-senior executives, the definition of a worker is incredibly expansive. Okay, it's broadly defined to include full-time, part-time, temporary, seasonal employees, W-2 employees, 1099 employees. Basically anyone is going to be covered under this. And what does it prohibit? So as of the effective date, which right now is September 4th, it is going to be unfair method of competition for any person to, one, enter into or attempt to enter into a non-compete, enforce or attempt to enforce a non-compete, or even represent that a worker or former worker is subject to a non-compete, right? So it's the entering in, the enforcement, or even the posturing or illusion to another party that someone is subject to a non-compete is all going to be prohibited. Okay, like I said, incredibly broad, right? This will affect virtually every single person that has a non-compete in their contract, which, by the way, the FTC estimates that number of employees to be in the hundreds of thousands in our country. All right, now the bifurcation of employees. We have non-senior executives, that's what we've got here, and then senior executives. So the prohibition remains largely the same. The only difference is that if a non-compete for a quote senior executive was entered into prior to the effective date, so prior to September 4th, that actually will be enforceable under this rule. So that's the big distinction. You still won't be able to enter into a non-compete with a senior executive after September 4th, or the effective date, but anything that's in existence now, or anything that's entered into between now and the effective date, would be enforceable. What is a senior executive, you ask? Well, that's a great question. Senior executives. There's really two prongs to satisfy here. One is the employee has to have a compensation exceeding $151,000, $151,164 to be exact, and it has to be in a policy-making position. Okay, so the compensation prong first. $151,000, that's annualized, okay? That's not total compensation that you've actually paid that employee over the year. For example, if you have an employee that made $100,000 over 3 months and then quit, well, that person's annualized salary would be $400,000, and they would satisfy the first prong. That's important to keep in mind. So it's not just the money you've actually paid, it's what their compensation would look like if you annualize it over a full 12-month period, okay? And this is compensation. So that's salary, bonus, options potentially, other equity bonuses, all get contemplated in calculating this compensation amount. All right, that's the easy one. The next prong is policy-making position. This is much more vague. So what does that mean? Well, the obvious folks that would fall into a policy-making position are your chief executives. So your CEO, your president of a company, okay? After that, it gets a little more opaque because it says any other officer of a business entity who has policy-making authority for a business entity or their department, right? Or a common enterprise. Like I said, it gets a little vague, but they've defined policy-making authority as the final authority to make policy decisions that control significant aspects of a business entity or common enterprise, okay? Not merely influence, but actual decision-making authority. So, for example, if you are trying to make a decision as to whether to open up a new office, maybe a new location for your business, and that decision has to get approved by someone, you arguably do not have policy-making authority. Or let's say you wanted to roll out a comprehensive new marketing strategy, but that decision required the approval of someone else. You arguably do not have policy-making authority. However, if you are the CMO of your practice or business, and you are the last deciding factor, and you only have to notify your CEO or your board of directors, then it could be argued that you have policy-making authority. And as long as your compensation reaches that threshold, your non-compete that is in place right now would be enforceable after the effective date. Okay? One thing to keep in mind, this generally excludes day-to-day administrative activities or operational activities. So your practice manager or mid-level managers or department managers are more than likely going to be excluded from this. All right. That's the distinction here on the application of this new rule. We have non-senior executives and senior executives. Okay, for non-senior, the ban is total, right? Total and complete. For senior executives, existing non-competes would still be enforceable as long as these two prongs are satisfied. All right. What does the rule not ban? Okay. So as I had mentioned earlier, oh, actually, I see that there's a question before I move on. Yes, it will be adjusted for inflation. The metric at which it gets adjusted is yet to be determined. I would imagine it's going to be tied to CPI. But yes, it will go up. Great question. All right, so what does the rule not ban? I touched on it a little bit earlier. Restrictive covenants, that's the broad group of provisions that you might find in an employment agreement that prohibit an employee from doing something. So restrictive covenants like non-solicitation agreements or provisions are still going to be enforceable and you're allowed to enter into them. So those types of provisions would prohibit an employee from either trying to take or influence an employee, a current employee to quit, right, and join them. It could be contractors, same thing. If it interferes with their contract with you, that former employee is not allowed to try to influence them to leave you. Vendors, same thing, also applies to patients, referral sources, okay, you name it. Non-solicitations will still be enforceable as long as they're not so overly broad or restrictive as to be reconstituted as a non-compete in the FTC's eyes. Okay, still a powerful tool for employers to have, so that's still available. Also, non-disparagement provisions, those aren't being touched, whether they're unilateral or mutual. Most of the time they're mutual, but those can still be in employment agreements or shareholder agreements or operating agreements. And then confidentiality or non-disclosure agreements, same thing applies. Okay, they are enforceable. You can enter into them, but as you're designing these, you need to keep in mind that the breadth at which the restriction applies is now going to be suspect, right? It's going to have to survive scrutiny. So with existing contracts that you have in place, it's worth a bit of an audit to understand how far down the spectrum you are in terms of in terms of restrictions. And then lastly, and I know that this is sort of a big topic for physicians, anyone who's a founder, I guess, but non-competes against the sellers of a business are still allowed. So it's very common practice that if you start a business and you end up selling it to, someone else, whether it's private equity or a strategic buyer, that buyer is going to put anywhere between a 2 and 5 year non-compete in place on the owners of that business. Okay, that is still going to be allowed. Okay, the FTC didn't touch on these transition of business deals and the restrictive covenants associated with it. Okay, so what does this mean though? My concern here is with this overly broad and expansive understanding of what a non-compete is and also who it's going to touch. It may have a bit of a chilling effect on some of the valuations that businesses, especially medical practices, get on sale. Because a common practice is not only the sellers of the practice, but also all of the providers that are employed, whether they're physicians, mid-levels, specialists, whatever it is, all enter into new employment agreements with the buyer that have these non-competes. And so if that's not available, it could have a chilling effect on the multiples that we've been seeing in the industry over the last decade. So that's something to keep in mind. It may have an increased pressure on wages, at least that's what the FTC is arguing. But if you're the owner of one of these businesses or practices, you want to keep this in mind, especially if you're contemplating an exit. Okay, where does that leave us, right? We've covered the rule, we've covered the exceptions, we've covered what has been left intact, some of the impacts that I potentially see. Now, is this something we have to worry about, right? The FTC, when they finalized their rule, I believe on April 24th of this year, the effective date was scheduled for September 4th. Okay, that's just an operation of law whenever there's a final rule that gets approved. Almost immediately, okay, lawsuits were filed. We have 3 in particular that we're tracking. The first one was filed in the Northern District of Texas, a federal court. That's called Ryan LLC versus the FTC. Another one the very next day, I believe, was filed in the Eastern District of Texas, and that's the Chamber of Commerce versus the FTC and Lena Khan, who is the commissioner. And then we have ATS Tree Services LLC versus the FTC. That one's actually filed in the Eastern District of Pennsylvania. Now, one thing to note is these 2 Texas cases have been consolidated into the Ryan case. And so that's really the only one that you need to keep track of if you're doing that. And we have an update here, which I'll present on the next slide. But one thing to keep in mind is all these cases have very similar claims. First, they're asserting that the FTC lacks the authority to make such a substantive rule with far-reaching impact, which means, the law that created the FTC and empowers the FTC did not give them this authority. The second one, which is a common challenge in these types of situations, is that the FTC acted arbitrarily and capriciously, okay, in passing the rule. That means that the rule wasn't reasonable, it wasn't tailored to specific events, and essentially is overly broad. Okay, so keep that in mind, because the Ryan court actually released a interim order, which is annoying for its own reasons, but hey, that's the way it works, on July 3rd, where the judge actually agreed with agreed with Ryan. Okay, Ryan brought a preliminary injunction to try to stop the ban from going into effect, and the court said that the plaintiffs, Ryan here, met 3 of the requirements for receiving relief for a preliminary injunction. And those 3 things are the likelihood of success on the merits of their claims, the irreparable harm that the plaintiffs may face if they don't get injunctive relief, and then the sort of catch-all that the courts like to look at is balancing the equities and public interests, right, of allowing the rule to move forward. All right, so on the first one, likelihood of success, the court actually made this very thoughtful and I would say very well-researched opinion, about 33 pages, where they really dove into this. And their conclusion is that the FTC lacks statutory authority to issue rules defining unfair methods of competition. Okay. What does that mean? Basically, the FTC has the ability to make housekeeping rules, administrative rules, operational rules, things like that, but not substantive rulemaking. They're claiming that is properly the jurisdiction of Congress, not the FTC. Then on the claim that it was arbitrary and capricious, well, they're saying that it was overbroad in its application, right? They would affect every class of employee in every industry in ways that were not going to be fully understood, fully researched, fully appreciated, and would have impacts far exceeding what they anticipated. And then lastly, the balance of equities and public interest. It's easier to maintain the status quo. That's essentially what the court decided on. So the preliminary injunction, right? We're looking at this. The court is ruling in favor of the plaintiffs. Great. We think nationwide ban on applying the rule is going to go into effect. Things are going to get stayed, but in a very made-for-TV twist, the court decides that no, this is only going to apply to the specific plaintiffs in the case. That means only Ryan is able to benefit from this injunction. The rest of us in the rest of the country are still staring down the September 4th deadline. And the reason why I say this is a made-for-TV twist is because this is a preliminary court ruling. by August 30th, I believe a mere 5 days before the proposed effective date, they said they're going to hand down their final rule, or excuse me, their final order. So what does that mean? First of all, most of us are anticipating that the court will, in fact, put a nationwide injunction in place, and it will stay the effective date. However, there's no guarantee, which means we all have to prepare for a September 4th effective date unless one of these other cases moves faster. That brings me to compliance. How do we comply? Well, the reality is that it's relatively straightforward on how to comply. The question is, how do you create strategies to mitigate the effects? So compliance, we need to evaluate existing employment relationships for non-competes that are actually in the contract, and then any clauses that could be interpreted as having the same restrictive force as a non-compete. Think about the confidentiality agreement I mentioned earlier. Employers have an affirmative duty to notify any employee that is subject to the non-compete, and they must do it on or before September 4th. Okay, that's an affirmative duty. That is a written statement saying that their non-compete was in place. It's not going to be effective. It can't be enforced. Okay, so that's what's going to trip people up. Most likely, I think. So waiting until the very end to know if it's going to apply to you could be problematic. So quick question that I'll generalize a little bit for everyone. What if someone who has a non-compete in place now quits before September 4th, and then the September 4th effective date occurs? What happens with their non-compete? And the answer is that if you are a non-senior executive, that non-compete is not enforceable after September 4th. Okay. If you are a senior executive, it would still remain enforceable. Obviously, that's conditioned on a lot of other factors, right? But in terms of the rule itself, that's how it would be applied. Also a great question. Okay, strategies. What do we look at? So as a practice or a business owner, first thing, we want to pay close attention to these cases, right? Because as the judge decides the merits on this, it's going to impact your compliance requirements. It's going to impact your timeline. So we're going to want to pay close attention to that. On the assumption that September 4th is moving forward, you're definitely going to want to audit those employment relationships like I was talking about. And let's say you're in a position where you have an employee that you value. There is an argument that we could craft employment agreements that put them into a position of policy making authority in order to have those restrictive covenants that non-compete be enforced. It's a bit of a gamble, obviously, because you are ceding some control by definition by granting that person a policy-making position. So something that you want to evaluate very closely before making those decisions. And then obviously you have to act before the effective date. If you wait until a couple of days before September, it's going to be too late to roll any of these things out, even if you want to modify your employment agreements to try to get into the senior executive exemption. Okay, what about the strategy for physicians, employees, and workers? Well, do the opposite, right? Make sure your language doesn't include any language or any authority to make policy decisions. And if there is one in place, it's an opportunity to leverage that into better compensation structures or potentially better rights elsewhere in the contract. Okay. The other thing that we can look at is using these expansive confidentiality provisions to try to come up to the line without crossing over it, and be prepared, to act on short notice, because, these court cases, at least recently, everyone has had a bit of theatrics, I think, in the judiciary, and I would expect nothing else for this. So be ready to act. All right, guys and gals, I really appreciate your time tonight. We ran through this pretty quickly. I wanted to give everyone an update on the status of the rule, the elements of the rule, right? And then some real world advice on how to prepare for it, how to evaluate it, and, how to get geared up for a pretty monumental change. Now, I do have to admit, I'm skeptical that September 4th will hold. As we went through, incredibly broad rule that will impact hundreds of thousands, if not millions of workers potentially in the US. These things almost never survive their initial final rulemaking and will get kicked back to the courts for revision or might be struck down in totality. That being said, it's not 100% guarantee, so being prepared is really your best defense. Here's a little information about me. Don't necessarily need to go into that. And with that, I appreciate your time and have a good evening.